We'll call the meeting to order, and if you would please stand for prayer. Dear Heavenly Father, we are so very thankful for your many blessings upon this great country, our community, and our friends and neighbors. We ask for your strength, guidance, and wisdom this evening in our deliberations. And in your Son's name we make this prayer. Amen. Amen. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. We have a quorum this evening. I thank my fellow commissioners for attending. Announcements.
Thank you, Mr. Chairman. I have two announcements. You'll notice at the agenda at your place, we'd like to add an additional item under new business. We called it public input portion of the comprehensive plan. I'd just like to take a few minutes to talk with you about that and get some feedback at the end of the meeting. Also, referring to the planning update, we had tentatively scheduled the Sheets case on Route 3 for Wednesday, June 21st, but it was not ready in time to be advertised, so that one's going to shift to July 5th. Therefore, we have no items right now on the agenda for June 21st, so I'll also bring up under new business at the end of the meeting if we still have nothing headed to that meeting that we can cancel it.
Very well. I assume everybody's had a chance to review the May 17, 2017 minutes, and if there are no comments or questions, I'll take a motion.
So move. Approval.
I'll call the vote. Thank you very much. Motion passes. I don't believe we have any unfinished business. We'll move into the public hearing portion. R16-0008, Par 5 Development, LLC.
Thank you, Mr. Chairman. This is a request to rezone approximately 3.5 acres from A3, Agriculture 3, to Commercial 1 with proffers to allow for a Dollar General store on a portion of the property. This request is made by Par 5 Development, LLC. Staff is recommending approval with recommended revisions to the proffered conditions. I'll go into those in greater detail later, but it's just clarifying the language, no substantive issues. Here is an aerial image of the property outlined in red. There is an existing historic house on the property. This house is documented with the Department of Historic Resources as a unique example of the Italianate style and dates back to 1875. The property is surrounded by other agriculturally zoned properties, in addition to a number of Commercial 1 and Commercial 2 zoned properties that make up the existing rural commercial cluster on this segment of 208. Those businesses include Joe Pine Builders, the Lake Anna Market, there's a motorcycle shop here on this corner, as well as Watson's Mulch and Stone business. All of these businesses are within a half a mile, and there's some additional commercial properties even 3 miles away, being the 208 Variety Store. Here's the generalized development plan, which shows the entire 3.5 acres and the proposed subdivision of the 1.65 acres, which will accommodate the Dollar General store. The remaining acreage comes to 1.88 acres. This includes the house. The immediate plans for the house are to do interior renovations to convert it for office use. Not aware of any exterior renovations to the house at this time. There's enough acreage here on this remaining portion for it to be developed for commercial use in the future, but there's no immediate plans at this time to do so. Access to the property will be provided with a shared access point serving both the Dollar General and any future commercial development on the remaining portion. This shared access is, of course, consistent with the county's access management policies and as well as the interparcel connection to this remaining portion. The Dollar General store is expected to generate 528 trips per day, 46 of those being in peak hour. This amount of traffic doesn't trigger a required turn lane. Of course, as this remaining parcel develops, there may be uses that would increase the trips to warrant a turn lane at some point in the future, but it's not required at this point in time with just the Dollar General. Here's just a zoomed in look at the Dollar General store. It's approximately 9,000 square feet. You can see the associated parking, landscaping, the dumpster pad here. The applicant did add additional landscaping here to the rear to limit the visual impact to those residential properties along Fenton Road. The applicant has provided architectural renderings. You'll see it's a hardy plank siding with a brick veneer, a standing seam, metal roof. These elevations have been proffered. And they also provided rendering of the monument style sign, and this has been proffered as well. The applicant's proffers consist of standard development in conformance with the generalized development plan, and they proffered the building and sign architectural renderings. This was the only language that staff had some recommended changes to. Right now the language is a little vague that as far as what those architectural renderings, do they apply just to the Dollar General store or any future buildings? And I believe this applicant will clarify tonight, but the intent, and they are intending, I believe, to revise the proffers to make it clear that the architectural renderings are for the Dollar General store only, but they did add language that any additional signage on the property would be monument style. The key findings as part of staff's analysis in favor is the Dollar General store will provide a shopping convenience that currently doesn't exist in this area except for across the lake in Louisa County. This will provide an increase in the tax revenue for the county and in the businesses as well. It's consistent with the county's access management policies, and with the proffer of the monument style signage, it does create a design standard for this corridor. Findings against is that Dollar General is a national retailer. It's going to be the first to move into this portion of the county, and that it could begin to change the rural character of the area. That concludes my presentation. Again, staff's recommending approval with the recommended revisions to the proffers, and I'm happy to answer any questions.
Mr. Smith?
Yes. First question is on the 528 vehicles per day. Is that what is expected to visit the location, or is that an additional 528 vehicles on the road?
That is for the site, to visiting
For the site.
to and
So
from
no,
the site.
no additional vehicles.
Right.
Okay. There is an additional land there that can be used for additional businesses. So in the future, if a turn lane is needed, we could have that put in. Is that correct?
It will depend on what locates on the property. If it's another convenience store type of retailer, then it most likely would trigger the need for a right turn lane. If it's something like an office or even a medical office or something like that, it probably wouldn't. So it's going to depend on the intensity of the use that locates there.
Do we have any information on vehicle accidents, crashes in that location?
Yes, sir. From the year 2013 to 2015, there was a total of 4 accidents, 2 of which were there at the intersection of Lawyers and Courthouse Road, and the other 2 were behind this site just north of the Fenton Lawyers Road intersection.
Thank you.
Yes, ma'am.
To follow up on Mr. Smith's question, and about a turning lane, and you stated that if there was other businesses which might locate there, it might require a turning lane. Then who pays for the turning lane?
That business would. as part of their site plan, as part of their construction plans, if the use generated enough traffic that it required an upgrade to the entrance, then that development would have to pay for that.
So there's no shared cost in that, if that would happen? No.
That's something that could be, I suppose, negotiated privately, but not as, it would be tied to that construction plan of that future use.
How about on the other corner? Because I personally believe that those two corners are going to establish a business. So the same would hold true. Am I correct?
Any entrance improvements that are required at the time of construction plan would be the responsibility of the developer.
Okay. Thank you.
Kim, while we're on the trip, the number of trips, is that based on the trip generation manual, or is that based off the store's historical data?
The trip generation manual.
So do we have data that this store would generate? That would be different than what the...
We could ask the applicant. I don't have that data.
Yeah. There are enough of these stores around. I think we can get a good handle on the traffic it does generate. And then to your point, I'd like to see how that triggers into a turning lane or not. So any other questions or comments? Mr. Burns.
You know, Kimberly, and I'm assuming VDOT's looked at the GDP and commented on it. They
Yes,
were
sir.
fine with the distance from the entrance to the intersection.
Yes, sir.
Okay, and then at this point, they didn't mention a turning lane. They were comfortable with the way the commercial entrance was as it is now,
That's
correct?
correct. Yes, sir.
Okay, thank you.
Any other questions or comments? At this point, we'll hear from the applicant.
Good evening, Mr. Chairman and members of the Commission. For the record, my name is Kerry Hutcherson, and I'm the attorney for Part 5 Development Group, the applicant here in this case. And I also have with me tonight Mark Williams. He's our engineer. And we also have Jody Bland. He's from Part 5 Development Group. And we can all answer questions for you that you may have. I just wanted to make a couple additional comments to what Ms. Pomato said. First of all, of course, we do accept the staff recommendation for approval subject to our proffered conditions. And just want to follow up on what she said about clarifying the proffers regarding the architectural renderings. We've added some language in the proffered language now to clarify that the architectural renderings would just apply to the Dollar General store. In addition to that, I want to add a couple of things as far as how this particular store will benefit the county. One, it's going to add, in terms of construction costs to this site and to the county in general, over $1 million in additional real estate value that the county will realize as increased tax revenue. In addition to that, it's going to be providing business opportunities for local contractors. This is because Par 5 oversees development and construction of its stores for Dollar General as the general contractor, and they give a priority to local contractors. So that money that's invested in constructing the store will go to bolster the local economy as well. And I just wanted to emphasize that this is something that the comprehensive plan recommends. This is a site that is recommended for commercial use in the comprehensive plan. So this is very much in keeping with the county's policies and what the county has advised it wants developers to do in this area. I think Mark Williams can tell you a little bit about the traffic counts and what they're based off of, what the actual counts are based off of. So I'll yield to him for a second.
Good evening again. My name is Mark Williams. I'm with Wilmark Engineering, site civil engineer representing Par 5. To explain where the trip generation came from, on the concept plan, it's based off of the IT trip generation manual, and typically they're pretty conservative in the numbers. Based on the historical data for Dollar Generals, the actual numbers are lower. The total daily traffic let's see, it's listed here as, based on the ITE manual, is 528. And in general, based on historical data, the total daily trips on average are around 350 range. So it's the actual numbers are actually lower.
Anything else?
I think at this time, we'll just reserve any other time for questions later after the public hearing. But of course, we do respectfully request your recommendation for approval of this case. And we've been working really hard with staff to make sure we have a good product here. And I think we have accomplished that. So just let us know if we have any other questions we can answer for you.
I have some questions.
Sure.
How many employees do you plan on having there?
Let Jody speak to this for a second.
Typically, an average shift, you're probably going to see one manager, 2 employees. With it varies by the busyness of the store, quite frankly. So I would guesstimate 8 to 12 new employees, new jobs for the area.
Okay. And will you be serving any type of fast food? Selling any gasoline? What kind of products do you carry?
It's general merchandise. There's a little bit of grocery, paper towels, some clothes. It's kind of a gamut. It gives you an opportunity to fill the gaps in your needs. It's not necessarily meant to be your one-stop shop, but they try to provide a variety of items that will, covers general merchandise.
Thank you.
Any other questions? Yes, Mr. Barnes?
The first question I had is the particular design that the elevation designs that we saw here, is that specific to that particular site, or do you have it in other locations?
Technically, we could take that render and take it to other locations. That is a non-standard prototype. It is more expensive to build than a standard prototype, so that's not something.
Yes, it's much nicer. I'm not criticizing it.
Yeah, we typically we wouldn't carry that over and over and over.
Yeah, because I know Dollar General in the past, because there's one being built at Stafford Courthouse.
Yes, sir.
And that one is considerably different.
Yes, sir.
Than some of the other ones, which
This
is also more.
Very nice store.
Right, very nice. My second question that I had is on this traffic count, like for example, there's a Dollar General over in Louisa, which isn't too far. Do we know exactly? I know generally speaking, you alluded it was much less than the 528, and I would assume the traffic one, the one over there wouldn't get any more generation than the one on this side of the lake.
That's correct. I would actually expect that this particular store would generate less traffic than the average Dollar General.
Yeah, due to the other commercial that's over next to the Dollar General. 'Cause you got a lot more
Well, that
activity.
and the actual traffic volumes on Courthouse, based on the 2016 VDOT numbers, the total average daily traffic on Courthouse is only about 7,400 vehicles a day, which is a pretty low count. And there's that road in Fenton. Fenton actually only has about 130. So the overall traffic counts for those roads in that area in general are pretty low, which would indicate that on average it's probably going to be a lower number of trips for this particular store than a store in a higher commercial area, higher density area.
Thank you.
That's a weekday count? That's your typical weekday?
Yes, that's a typical weekday count.
And do you know what it is on a weekend?
Based on the ITE manual, when you're reviewing the weekday and the weekends for this particular use, they're fairly similar. Generally, they're less on a weekend, but then again, it depends on the location and if you're in an area that has more recreational uses, you're going to see higher trips on a weekend than you would on a weekday.
Yeah, I'm wondering, since the proximity to Lake Anna, right, that we'd probably see a higher volume on the weekends, but I don't have the data in front of me, so
It's hard to say.
Ms. Smith?
You all are a corporate business, correct? Do you sell the franchise? Explain how that works, or if in fact you do that.
We contract with Dollar General. We own the lease. Some stores we own, some we sell. It just depends on the market conditions in said store. They are a valuable product on the commercial market. We own in-house right now. I think we hold 10 ourselves, and we continue to build and sell throughout Virginia and North Carolina.
Thank you.
Any other questions for the applicant? Thank you. At this time, I will ask anybody else that wants to speak in favor of this application, if they want to step forward.
I have a sign-up sheet.
You have a sign-in sheet? So
George
we'll go-
Cartuti, followed by Paul Jum.
Excuse me, Mr. Chairman?
Yes.
Did you open the public hearing?
I will. I'll open up the public hearing for comment. Thank you very much. Go ahead, Paulette.
Good evening, Mr. Chairman, Commission members, and staff. My name is George Cartuti. I live at 6274 Courthouse Road, Spotsylvania, Virginia. I've been a resident of Spotsylvania County since 1988, and my family owns a business there, 208 Variety Store, which is approximately 3 miles from where this commercial development's going to take place. I'm here in opposition for it. You know, running a small family business is very difficult and challenging. My grandfather owned a convenience store. My father owns this specific one, and I'm going to be a third generation taking over. And I'm really, really scared that this is going to have a major impact on all small family businesses out that way. When I look at it, I say to myself, well, there's a Dollar General right across the bridge in Louisa County. Why do we need to put another one here? 10 minutes away, maybe. So that's my biggest concern. You know, we hear it's going to generate some employment. Well, it's going to take away from the other businesses, trust me. I don't have any data to prove that, but you'll see it if this gets approved. There's 601 Variety Store, there's Lake Anna Market, there's Post Oak, there's the barn. If it takes 1 or 2 away from each, if it takes 2, that's 8 right there, and us, that's 10. So I'm not here in favor of that. You know, over the years, what I've seen is profit margins have dropped. In fuel, there's not profit. You want those customers to come inside. We do sell fuel there. But I really feel that if we proceed with this, then there's going to be some issues with all the small mom and pops out there. So I would respectfully ask you all to just think about that. I know that from this point, you know, whatever decision you make, it's going to go to the Board of Supervisors, and at that point, we will have to address whatever we need to address again. But just think about the little man, you know. Small family businesses are the backbone of the United States of America. And it's hard to see something like this happen. Thank you for your time.
Paul Jum, followed by Anne Millay.
How is everybody? I'm not good English, but I write down here, so I'm going to read. My name is Paul Jun, and I came to America from South Korea in 1977. I attended Washington Seminary and worked as a missionary for 20 years, 3 years in South Korea and 17 years in Florida. I have 3 brothers. One has served in U.S. Army, one in the Marine. Although my brother and I served in Korean Royal Marine Service. After I retired from being a pastor of 17 years of a Korean church in Florida, my wife and I moved here to Spotsylvania. We purchased a convenience store gas station in Spotsylvania County of Courthouse Road. We have been operating that business for 10 years. My wife and I are the only employees. and we work alternate shift over 12 hours each day. When we bought the store, the Food Lion and Dollar General over the outside of Lake Anna were not there. 2 years ago, the Food Lion and Dollar General opened and cut our business and flow the traffic. Last year, we had a short sale our house because the business was so slow and moved into a house our daughter owns. In the process of selling the house, we lost a lot of money. I worried that if a Dollar General is put into the area 1 block from my business, it will force us to close. There is currently a Dollar General within 6 to 8 miles of our location, so what is the need for another? If they are doing so well, why would they want to build another so close to them? People in this area of the country is used to driving distance to go to the market and other stores. We checked with 7-Eleven to see if they would build a store here before we bought the Exxon station, but they refused to because of the number of people in the area is not enough. Their ability to buy in large bulk and sell product much lower where I live, leave me with just selling gas and lottery tickets. The profit made on lottery and gas is not enough to keep my business open. By approving this code change, it will kill our living food, and my wife and I will be unable to continue in this area. We are already at the age where it is very difficult to make life changes. When winter comes, the number of customers we will have very few. We must set aside money from the busy season in order to survive the slow season.
Mr. June, if you'd finish up, please, your time is up.
Thank you.
Thank you.
Hello, my name is Ann Melly. I live at 6733 Lawyers Road, about 2 miles from this location. I wanted to speak today. I support a commercial development in this area. I've lived at that location for about 10 years. And yes, we are used to driving, but it is nice to have local stores. I'm a customer of both the previous speakers, and I can attest it's nice to have the local stores. I'm not sure, based on the quality of what I see in Dollar General, that it's really going to add anything to that area. I also support this as a commercial location because I don't think it's going to get any other use. Once the county allowed the Harley-Davidson biker sales place and party site at that corner, I don't think anybody's going to want to live there, and there's not going to be much other use of that land other than commercial development. As I said, the Dollar General is only about 10 to 15 minutes drive, exactly 6 miles away. I work for the Spotsylvania Volunteer Rescue Squad, and I don't know where they got those accident statistics because I myself have responded to at least 4 traffic accidents at Lawyers Road and 208 within that recent time period. So I don't know where they're getting those figures. That intersection is extremely difficult to navigate, especially during the summertime. There's a lot of livestock equipment going through there. Watson's runs heavy logging trucks down Lawyers Road that are coming in and out of that intersection. and they're large mulch trucks. And there's just a lot of traffic, and I navigate that intersection every day, and it's very dangerous, and I'm really worried about the volume of traffic that you're talking about coming in and out of that store, and I'm shocked that VDOT agrees that there shouldn't be a turn lane there. I would strongly urge you to work with VDOT and not have the access into the store only from Fenton Road and not accessing directly out onto 208. If it must access out onto 208, I strongly urge you to put in an extension of the existing turn lane, which is the right turn lane from Courthouse Road onto Lawyers Road. That turn lane is too short anyway for the buses and the trucks that are turning there, and generally has created a lot of near misses with traffic slowing to turn onto Lawyers Road from a 55-mile-an-hour highway. 208 is a 55-mile-an-hour highway. And I've seen traffic in all these stores coming in and out of those locations, and I've had near misses myself with high-speed traffic. And I'm shocked VDOT is continuing to tolerate that, and I hope you will not. That right turn lane does need to be extended anyway, and I'd urge you to have them extend it all the way to their store and create a turn lane into there if you must come off into 208. I'd also encourage you to take a look at Fenton Road because it's a narrow road, and I don't understand why it's okay to put 350 to 500 cars on that road a day and not think that it also needs some improvement. And I'd urge you to have somebody really go take a look at that and make sure that their designs are accommodating traffic coming and going, not only into this business, but also into the motorcycle business there and safely entering and exiting off of Lawyers Road. Thank you very much for your time.
Thank you. Anyone else? Yes, sir.
Hello, my name's Bob Seifert. I live across from where this proposed building's going. And I'd like to find out about the construction part of it. Because like the lady said, on the corner there's a motorcycle business, and there's a lot of us that ride, and due to the mud and the rocks and all that kind of stuff, I'd just like to try to find out about the safety of, you know, the traffic for us and other people in that area. And plus, I'd like to find out about the construction entrance, because like the lady said, 208 is a 55-mile-an-hour zone. That's all I.
Thank you. Anyone else? If the applicant wishes to address any of the comments.
I'll take the first couple things and pass it off. As far as the comments go regarding impact of this store on local businesses, I'd like to make a couple of points. First of all, we certainly aren't intending to drive out any local businesses and would like to coexist with local businesses. Second of all, that's typically what is the case when we've developed Dollar General stores in areas where there are local businesses around. The local businesses continue to operate alongside of the Dollar Generals. And part of the reason for this is that Dollar General store is serving a market that's a little bit different than the market that the other stores, the local stores, are serving. I think when we were talking about, or we were looking into the items sold, and I think Mr. Smith had some questions about that earlier, you can hear what Dollar General provides is a little different than what the gentlemen who were just up here were saying they provide at their stores. So I don't think we're going to have direct competition. And in fact, Dollar General has a list of types of stores that they consider to be direct competition because in their vast experience, they have found that these are the types of stores that are considered direct competition, and convenience stores are not on that list. Dollar General doesn't consider convenience stores to be direct competition. They think that's a use that they can coexist with. And that's based off of their past experience developing all over, all over everywhere. So, and then finally, I'll make one more point, which is simply that the consideration of impact on local businesses or any other businesses, you know, when it's considered as a factor in a zoning case, that's something that the Virginia Supreme Court has said is not a valid consideration. It's not part of the police power the local government has. And I can give you the citation for that case later if you'd like. But so this is really something that is going outside of the legal parameters of a zoning case. And then in terms of crash data, Ms. Pomato was citing crash data, I believe, from VDOT's site. She can correct me if I'm wrong. I also went on the VDOT website where they have crash data, and anybody can check up on this if they'd like. From 2011 to 2017, which is the data they have on their site, for the entire length of Courthouse Road, there were 913 crashes. At this intersection at Courthouse and Lawyers, 7 crashes for the same time period. So, you know, as a percentage of all the crashes that occur on that stretch of road, this, you know, it puts some perspective on this particular intersection. It's really not an area where a lot of crashes are happening relative to the rest of the road. And I'm going to let Mark say a few things about the construction entrance for when the store is going to be constructed.
Real quick, a couple questions that came up related to traffic. I wanted to point out that the volume on Fenton is not going to be nearly as high. The number of vehicles using that road to access the Dollar General is going to be pretty low. And then to address the gentleman's question about construction safety, the construction entrance would most likely be off Fenton Road just because it is a much lower volume of traffic, and we don't want trucks coming in and off of the main road. And of course, we'll adhere to all the erosion sediment control requirements, you know, wrap the site in silt fence and contain mud from going on the local roadways and rocks and that sort of thing with the construction entrance.
Any other questions or comments at this point? I will close the public hearing. And any further discussion from the commission? At this point, if there are none, I will take a motion on this application.
Chairman.
Yes, sir.
I make a motion that we approve R16-0008 with the recommendations of county staff.
Have a second on that?
May I add?
Yes, ma'am.
Mr. Smith, businesses I know that's going to settle are going to happen in that area, absolutely. That is a 208 commercial corner that's really going to happen. But I'm still not satisfied with the turning lanes, not being that you don't have to put a turning lane in. I am concerned about, I believe, did they say Bentley Road? Is that what it is? Benton Road. I am concerned about that. It is very narrow with the 2 lanes there. I don't think that's where, I don't think that should be the turning lane in that area. But that's just me. I'm not an expert in transportation. But, and then I have a concern. As I stated just a minute ago, that is an area that's going to, I believe, be commercial. But I have a problem of not all of the establishments that would probably settle in that area would be treated alike. That would have to be something that would probably be differently. I believe that I would like to add to your motion, and I do support businesses, but I would like to add to your motion that the transportation issue be studied more than what it has at this time, and that it be brought up to VDOT of a concern of other establishments being in that area and what it would probably require at that time. And that's, I like for that to go into the motion to be a recommendation to the board.
Would you like to revise your motion?
I don't know if I'm clear on exactly what you want.
I want VDOT to get with county staff and to review the area that we're speaking of for potential growth in that area and how they would address that in the traffic count being increased in that area, and also on Benson Road there.
Benton Road.
Benton Road.
Yep.
To make sure that they are still completely, second opinion, completely satisfied from VDOT before this county would say, yeah, that's okay. But I would like to have another opinion to go to the Board of Supervisors, if they would, please, a second review of that.
I don't have a problem with that. I don't know if they do that. I mean, am I correct? They've given us their recommendation from VDOT to the county staff?
VDOT has approved the generalized development plan showing the entrance as a commercial entrance without a turn lane. I will say that there is a taper. There is an extended taper leading into the entrance. They've approved this design. We had additional conversations today after I spoke with Mr. Smith with our traffic engineer, Dan Cole, and he re-examined the design, the traffic. We looked at hypotheticals of what could locate on that remaining parcel and what could trigger an additional turn lane, and based on his second analysis of this, the turn lane just wasn't warranted. Now that doesn't mean that a turn lane certainly isn't a safer improvement. It always is when you have a highly traveled corridor like 208. But this Dollar General just simply didn't warrant that turn lane with the traffic that it's generating. There may be an additional, a future development may trigger it, but it might not. It just depends on what locates there.
When boats travel up in that, and you take, you pulling boats and whatever in that area also. You have farm equipment, you have boats, and you have all of those things, which is wonderful. Please don't get me wrong on that. But I just always have been a person who's been concerned about safety. And if VDOT says no, then that's fine. They don't want to do a second opinion on that, but something to me.
Yeah.
That's fine. But I just feel that from the commission that we would recommend a second opinion from VDOT if they would so do. Thank you.
So do we need to restate the motion to be clear? If we can,
He
if
can
we
never
can do
restate
that?
what I said.
Can we have some more?
I'll give it a shot.
Go right on.
I make a motion that we approve R160008 with the recommendations that county staff has made, and also asked VDOT for second opinion on a turn lane there at that location.
That's right. Is that okay, the lawyer?
And I want to be clear, are we talking about a left-hand turn lane into the site heading north or east on Courthouse, or are we talking a turn lane, the right-hand turn lane?
I was taking it to be the right-hand turn lane, but you are correct of asking that question.
The right-hand turn lane, okay, I want to be clear on that. I'll take legal counsel on this.
Ms. Carter, can you use roads, or with the assistance of planning, can you use roads to delineate which road you want the right-hand turn lane on, so it's very clear, because you've got 3 roads involved here.
Courthouse, I might have 4 or 5. Is that right, Mr. Barnes?
Courthouse
is
Road
what I
is
want.
what you're
Yes,
talking about.
yes,
Right, so
Courthouse.
Courthouse Road, Route 208.
Yeah,
Courthouse Road 208 right into the site, okay.
into the site.
Thank you.
Yes, yes.
Okay, so I believe we're clear on the motion at this point.
I mean, the gentleman's going to say something.
I have a question. Can we discuss now?
Yes, we can.
We have the
Yes, a
motion. Thank you,
second.
Mr. Chairman. I've got some real concerns about the traffic issues too, because I'm not sure. I have a boat, I have a trailer, and I go to the state park, and I go to the marina, so I see what's there. So I think it's, on my behalf, I've got some real concerns about, especially summertime, peak traffic, going to the lake, and no turning lane there. And then the other concern I have is that whole parcel, we are getting ready to zone it from agricultural to C3, so it's going to open. And I know some other things may kick it later, but I just want to, I've got some real issues concerning the traffic there. And if, and because of that reason, I'm kind of hesitant to support it at this point because of that reason. Because it is, and I commend them. I love the architecture. I think the building's good. I'd like to see the commercial come there, but I think we also have an obligation to that intersection and anything that we can do there. And I understand VDOT right now looked at it, and Ms. Carter's suggestion and your amended motion may address it. It may not, but it's just certain times there that count is, I think, going to be more than what we think it's going to be. That's my concern.
Yeah, from my point of view, I'm happy with the motion. I would like to think that the supervisors get this approval from the Planning Commission with the strongest recommendation to include a turning lane as part of the approval process. However, I am satisfied with the motion we have on the table to address that.
Why are you shaking your head, ma'am?
Because we're getting into comments here that we have a motion, so.
I'm sure what Mr. Newhouse means is that he has concerns. I have heard you all express concerns about traffic, but nobody is suggesting that there be a condition on this proffer that
Correct.
A right turn lane be added to make
Correct.
the proffer more viable. I just wanted to clarify that.
Yes, ma'am. Thank you very much. So at this point, we have a motion, and we have do we have a second? I've lost track.
Yes, you did. Yes, you
Not
did.
on the revised, so.
Yes, Mr. Bullock seconded.
Okay, thank you very much. So at this point, I'll call the vote.
Wait a minute now. This is so that VDOT will review this again with
Correct.
staff. And I think the applicant would like to say something. Maybe
I don't-
address it. Can he?
If one of you were to call on the applicant to answer a question, I believe they would be able, because they will answer questions at your pleasure. So if you have a question you'd like to address to them, I believe they can come to the podium and answer it.
Do we have any questions we'd like to ask at this point?
Yes, I'll ask it.
Okay, go ahead.
Would you come to the podium? Legal counsel, make sure I do this correctly. We have discussed turning lanes and safety factors to save a life of a person, a people, a whomever, residents. Have you all considered in any way to look at this as maybe a safety factor that you would address?
Yes, ma'am. So what we are prepared to do, there's two categories of a turn lane. You have the taper, and then you have what is referred to as the storage lane. So right now there's a short taper. What we will do is extend that taper lane out. If you look at the actual traffic counts, the specific data associated with this development, it does not require a taper or a turn lane. And the applicant is willing to install a taper lane, even though it's not warranted. And
Is that on the GDP?
No.
It is not, okay. I don't recall seeing it on the GDP. Any other
So
questions?
we would, if acceptable to VDOT, we'll install a 100-foot long taper. So over a 100-foot distance, it'll go from 0 to the 12-foot wide lane.
Okay, thank you. Any other questions? All right, so we have our motion on the table. It has been seconded. And
Thank you.
Thank you very much. And at this point, I will call the vote. Are we ready for that?
Are we ready, Mrs.?
All right, so I'll call the vote. We have 5 for, and 2 against. The motion passes. Thank you very much. Next on our agenda, we have the discussion items for zoning update, ordinance 23-172, development plan, development review procedures. Jacob.
Good evening.
Oh my gosh.
Okay, just to start this off, just to reiterate, this is not a public hearing this evening. Staff is just coming up to the Planning Commission this evening to seek public hearing initiation of ordinance 23-172, the development review procedures. The impetus for this amendment, as well as the other ones that we've been going through for some time now, is based in Vision Strategy 85 of the comprehensive plan. This is a comprehensive plan implementation item to review and update the zoning ordinance, among other policy documents for the county. Proposed amendments this evening apply to numerous sections of the zoning ordinance, including required permits and approvals, permitted uses, special use processes, text amendments or with the code, variances, appeals of administrative decisions, building permits, occupancy permit, and zoning certification. In total, this represents a mix of building, zoning, and planning processes. So there's a number of different departmental processes involved here. There's a number of common amendments that we'll see throughout the proposal that you have in front of you. Many of the amendments are related to formatting, actually. They're not really substantive. They have to do with capitalizations, correcting numbering and chronology, correcting document references. As you'll see as we go through, some of the documents aren't accurately portrayed. Permit references and consolidation of sentence structure for clarity. There are clarity of vague references. There are code references, documents, policies, legal review clarifications, and edits as well, just to make sure the document's more readable and can be interpreted easily. Capitalization referencing county permits, forms, position titles for consistency with the comprehensive zoning ordinance efforts that we've been ongoing, just to make sure the document's consistent. We've updated code to reflect related amendments approved elsewhere. Examples including removing references to the agricultural 1 district, which was removed from the code in text in 2015. We've added mixed use ordinance references, which was added to the code elsewhere, but it was not reflected in this specific section. We've also changed our GDP requirements for special use permits to be consistent with what we already require for rezonings, both public hearing processes. So there are a number of things like that we've also done throughout the document that you'll see in front of you. If I start to focus on the specific areas this evening, first of all, looking at required permits and approvals. Again, we have the formatting amendments. One of the examples I said about referring to forms, occupancy permit is throughout the document referred to. The actual appropriate term is certificate of occupancy. So those type of things you'll see. In 23411J, we've corrected the zoning district references, removing the A1 district, adding PRR, and correcting reference to the VR district to V, resulting from recent amendments elsewhere in the document. In 23413, we've combined similar complementary subject matter related to review fees in the Unified Fee Schedule. It combines 2 subsections into 1. In permitted uses,
excuse me.
Sure.
Could you go back to that last thing?
Absolutely.
Maybe I'm missing out on something. What's PRR? What do these things stand for?
PRR are zoning districts. A1 was agricultural 1. PRR was the planned rural residential zoning district.
What's that? Subdivisions?
It's a subdivision type. It's a zoning district type. And in these instances, we're either removing them because they no longer exist, or in the case of PRR, I believe it was in relation to the chickens ordinance. PRR is an enabled zoning district for the backyard chickens ordinance. It was not addressed in the required permits and approvals for related to chickens, so we updated it and made sure that PRR was in there.
Okay.
The VR was Village Residential. That's what it historically was known as. Village Residential is a zoning district that the county has that had actually, there was no land zone VR in the county. Back in 2015, I believe it was, the county consolidated the Village Commercial District, which we do have some in the county, with the Village Residential to create a combined V district, and we essentially struck one of them out and created one district. So that's what's really reflected in that.
Thank you.
Sure. Moving on to permitted uses, these are fairly common, basic. We have formatting amendments. I believe most of it has to do with capitalizations. Again, we've changed the reference to occupancy permit to certificate of occupancy. There's not a lot substantive in there at all. Special uses, this is where we have a number of amendments. In addition to the formatting and the correcting the occupancy reference, in section 23453, sub-item A, we've clarified those who may file a special use permit application. It's a legal clarification. We were making sure it had to do with the owner or a moment, let me just go right to it. Basically, someone working on behalf of the owner. There's language in there that speaks to just person in general, and that's not very accurate. We need to make sure that there's someone legally able to represent an applicant in this for special use permit applications. So application for approval of a special use may be filed by any property owner or by any person acting under a valid power of attorney from the owner. That's the result, and that's historically how it operates anyway, to make sure that there's someone legally able to represent the applicant. In B, the pre-application meeting for special use permits is proposed to be amended from encouraged to a requirement. I would add, we've already required them for rezoning applications, which are also public hearing. That's a very similar process as a rezoning. We find these tremendously valuable for the applicants as well as county staff. It's an opportunity for an applicant to come before the technical review committee and discuss a proposal prior to it even being application submitted or any fees submitted. It's an opportunity for an applicant to find out what are the requirements, what type of application is going to be necessary, what are the technical comments ahead of time before that application. So it really helps them speed up their process and make sure they have a more full, complete application before they even submit one. It also can be a reason for an applicant to say, you know what, this isn't for me. I think it isn't consistent with the comp plan. There's some other factors in there that they'd like to consider ahead of time, and it's a really good process. So like the rezoning, we've proposed to make this a requirement as part of the special use permit process. And that would be in the zoning ordinance and will also be reflected in the application packet. In item C, we've clarified application requirements where appropriateness or applicability deviates from standard county forms. And this is actually where I'm going to also go back to that pre-application and where there's value there. There are instances where we may have a special use permit application that doesn't require or doesn't really have, isn't a proposal that necessarily totally aligns with all the application requirements. There may be some things that just aren't applicable to that application. And this proposed amendment actually allows a little bit of flexibility, giving the planning director the opportunity to identify things that may not be necessary as part of the application process and what we would need to make sure that it is catered to that specific application. We've also revised general development plan content requirements as part of the application submittal. This is for consistency with recent amendments we did with the rezoning application process. They're predictable as a result. If you're doing a rezoning or a special use, we're looking on a staff level, it actually saves us time too, because there's consistency with the GDPs and what's on there, how it's laid out, generally speaking, the information that's presented. So again, reflecting the fact that both of these are public hearing process, both require generalized development plans, we felt it was valuable to make sure that the generalized development plan content requirements for the application were consistent in the same.
Hey, Jacob.
Sure.
On the second bullet item, the pre-application meeting,
Sure.
From encouraged to requirement,
Right.
is that all, if we make that a requirement, are there additional review fees, or is that all part of the structure of the fee structure that we have in place? So how's that going to work?
That's correct. There is no fee for a pre-application meeting.
And that's one of the reasons that we like that too, because it, like I said, before they even submit any fees, it gives an opportunity to really.
Okay. Yeah, I'm sorry, I missed that part of it because I certainly don't want to be adding to fees that.
Agreed.
You know, okay, thank you.
Understood.
Yeah, thank you.
Moving on the special use permits in section 23454, we've clarified procedural details related to project review and public hearing scheduling. It's simply adding the chronological steps in the process for the public hearing scheduling. It's more understandable. Would also note that the application packets cover such details in depth. So if an applicant's not looking at the zoning ordinance, our application packets do go through step-by-step process. There really is there's no additional steps being proposed. There's no extras. We're just chronologically reflecting what's actually happening. In 23454, we've added a sub-item D, which states the county staff will schedule the application for a public hearing before the Planning Commission and submit a written staff report to the Planning Commission on proposed special use. And then also to clarify that if there's a map amendment filed in conjunction or rezoning filed in conjunction with a special use permit, the county shall coordinate the review of the proposed map amendment with the review of the application for the special use. So basically this is assigning jobs, assigning duties in the process. In section 23-456, we've made a revision proposed to a code reference related to public notice requirements in item A. Procedural details have been further elaborated on in draft B3, specifying a board of supervisors option during public hearing to continue the public hearing to a future meeting. Simply, the way the board actions were explained, they had the option in the zoning ordinance to approve the special use, deny it, or refer the application back to the Planning Commission for further study or review. Through legal review, we've determined they were missing one, and it was to continue the public hearing or vote to a future meeting. So we've added that just for clarity. In section 23457, use-specific standards for automobile, tractor, and trailer repair shops, places of worship, private schools, wineries in the A1, A2, and A3 and RU districts, we've proposed to remove from the draft ordinance altogether. And the reason for that is that these uses, with the exception of wineries, and I'll get to that, these uses appearing in the special use permit section are already subject to additional scrutiny because they have to go through a public hearing process and a special use process. They're subject to potential conditions to mitigate impacts. We didn't find it necessary to essentially proactively set conditions on applications, reflecting the fact or recognizing the fact that all of these uses are assumedly unique and should be reviewed based on their unique locations and their character. So we've removed those conditions. I refer to them as conditions because that's essentially what they are up front, these standards for a special use permit. As it relates to wineries, we've actually included those as part of the definition of agriculture back in an amendment that was approved in 2015. This is reflected in Code of Virginia farm winery legislation. So wineries actually are by right use under the agriculture. So there's no longer a winery subject to a special use permit as our code states. So there's no value in it anymore. Moving on to text amendments, kind of like what we're going through throughout this process. The text amendment process includes the formatting amendments, capitalizations, things of that nature. But also in section 23476, what we've done is proposed to add details related to the review and recommendation by the Historic Preservation Commission when establishing a historic overlay district or designating a historic landmark. I noted that in the slideshow, there's no substantive change that actually results. This language you'll read also appears in section 23734 in the zoning ordinance related to historic overlay districts. But simply because a change to the historic overlay district results in a text amendment within the code, we found this was tremendously valuable to add in this specific section because it relates directly to that process. And that's, so we essentially duplicated it within the ordinance. But in this case, where we usually try to get rid of duplication, we found this to be very appropriate added to the text amendment section.
So if there's a change to one section and you have this duplication, I would assume that that change would be applicable to the redundant section?
It should be. If otherwise, it's yeah.
So what's the quality control mechanism there to make sure we don't have a conflict? Is that something that your everyday?
I would say typically what will happen is if staff doesn't catch it as part of their update, it's caught during our legal review. We also subject these text amendment cases to legal review and try to make sure that and I don't want to speak for the attorney's office, but that's just how it plays out. As it relates to Division 8 variances, there's not an awful lot in this specific amendment. I believe it's a fairly short amendment section. This one actually applies to the zoning office and zoning variances. We have formatting amendments here. We've also updated and corrected a reference to the Code of Virginia that was pointing at the wrong code in the Virginia code. It may have been updated at some point over there, and we're trying to reflect that. Some of these sections of code honestly haven't been updated since the 90s, early 2000s, so they just need a refresher, and that's where we're trying to clean some of this up. In Division 9, appeals of administrative decisions, this is a situation where an applicant is looking to appeal the zoning administrator decision. We've added formatting amendments here. We've also, in section 23491B, we've included procedural clarifications related to zoning appeals, and I'm going to go... For instance, in 23491B, we've added language, for instance, any written notice of zoning violation or written order of zoning administrator shall include a statement informing the recipient that he or she may have the right to appeal the notice of a zoning violation or written order within 30 days. For a legal clarification, based on that 30 days, we stated that it's from the date of the decision in accordance with this section. So what we're doing is just setting that start date there, inclusive of the cost of appeal, location, forms, hours, and place in the filing of such appeal, and that the decision shall be final and unappealable if not appealed within that 30-day period. In section 23493C, we clarified that 4 concurring votes are necessary in order to overturn the zoning administrator decision by the Board of Zoning Appeals. That's just a clarity issue. And we've also had an update to correct the Code of Virginia reference in this section as well. As it relates to building permits, this one's very short. Again, formatting amendments. We've linked building permit issuance to the Virginia Uniform Statewide Building Code specifically, rather than tying it to site plans or the zoning ordinance. I've discussed this matter with the building official, and they stress that their building permits are based on conformance with the Virginia Uniform Statewide Building Code, and that's as far as it should go, and to have nothing else related to it. Frankly, the building office isn't really looking at the zoning ordinance as it is. That falls under the zoning purview, so we've made that change. We're getting to the end, I swear it. Just a lot of content. In Division 13, Certificate of Occupancy and Zoning Approval, we've corrected again occupancy permit to Certificate of Occupancy, or zoning approval depending on responsible party. There are some instances where the the reference should be either certificate occupancy or zoning approval. It really depends on what this covers both. So throughout the document, you'll see that. In section 23.4.13.1, we've proposed to remove item B pertaining to issuance of an occupancy permit. This has been supported through consultation with the county zoning and building office. The change is meant to focus on zoning related responsibilities administered by the zoning administrator. Again, we're trying to get away from the building office when we're talking about the zoning ordinance. So the occupancy permit is there's no value in that from the building's perspective. In section 23.4.13.4, we've done a full rewrite. We've simplified probably six sentences, 3 items down into 1 sentence. And this is related to the issuance of a certificate of occupancy. It's just a vast simplification of it, makes it simple. Section 23.4.13.5, again, procedural clarification, adding temporary zoning approvals may be extended by the zoning administrator. This amendment is supported by consultation from the zoning office. It adds flexibility. Right now, the way the language is worded, there's a firm 120-day deadline on temporary zoning approvals. We've allowed the opportunity for an extension with extenuating circumstances. The zoning administrator can give those extensions. And then lastly, again, it isn't a public hearing this evening. We are just looking for Planning Commission to initiate the ordinance for public hearings, and I'll take any question they have. Thank you.
Any questions? Other than what was already asked? Mr. Burns?
I'll make a motion if there's no questions, Mr. Chairman. Basically, I move that Plan Commission initiate changes to Spotsylvania County ordinances found in Chapter 23, amending and adding provisions related to Ordinance 23-172, Development Review Procedures, specifically Section 23-4.1, Required Permits and Approvals, Section 23-4.4, Permitted Uses, Section 23-4.5, Special Uses, Section 23-4.7, Text Amendments, Section 23-4.8, Variances, Section 23-4.9, Appeals Administrative Decisions, Section 23-4.12, Building Permit, Section 23-4.13, and Occupancy Permit and Zoning Certification.
You did an excellent job with that. Thank you. Can I have a second on that, please? I'll call, if there are no other questions, comments, I'll call the vote. And that is unanimous. Thank you very much.
Thank you.
Jacob, that was good work. Thank you. If we don't have any other discussion items, I guess we're moving on to work session for vehicle sales.
Thank you, Mr. Chairman. The item before you this evening has to do with vehicle sales within the county. This was raised at the board level as a concern. Specifically, Mr. Sabula commented on the used auto sales that are popping up along Route 1, many of them on non-conforming lots, very small lots with no improvements to the lots. So the board directed staff to look at vehicle sales and determine whether there was anything to provide more structure to the approval process. Vehicle sales are currently permitted in Commercial 3, Industrial 1, and Industrial 2 zoning. There are currently 104 independent dealers and 10 franchise dealers. So the franchise would be like the Ford dealer, and the independent dealers would be these used car sales. Some of the concerns that have been raised are the number of non-conforming zoned lots. So any lot that's already zoned Commercial 3, Industrial 1 or 2, and it may be a non-conforming one. It may have been zoned that since the beginning of the zoning ordinance in 1973, had very little improvements to the site. But because it's a non-conforming lot, they are able to get a zoning permit and operate on the site by right. Safe access to the site when you have these uses that may have been a house that's been converted and has a small parking lot, doesn't have a standard commercial entrance. Sometimes the safety of the access is a major concern, especially when it's off of a main road like Route 1. Providing sufficient area for loading and unloading vehicles. Mr. Sabula noted that he observed along Route 1 at one point a trailer unloading vehicles on Route 1 and driving the vehicles onto the site of the auto dealer. Display in grass or in drive aisles. There have been some concerns expressed about cars easing out into the VDOT right-of-way, parking on the grass, parking in drive aisles so that when customers come, there's no clear space for them to drive in, park their car so that they're able to look at the automobiles for sale. This is a map that shows the current commercial 3, I-1, and I-2 zoned parcels in the county. So you can see they're primarily located along the Route 1 corridor, Route 17, Tidewater Trail, and a little bit along Route 3. So on March 30th, the board adopted a resolution directing staff to prepare a code amendment. And the zoning amendment is in draft form right now. It's still under legal review, but I believe that there are very minor comments from what I've seen. Alexandra was just sharing with me before the meeting. And the proposal that is in the works right now is to establish a minimum lot size. So typically, the issues that we're seeing are on smaller lots. So the idea is to establish a minimum lot size for the by right use of these commercial and industrial properties as vehicle sales. And any site below that minimum would require a special use. And of course, anything that's already established would be grandfathered until they wish to expand their site. Then it would require a special use under that scenario.
Wanda,
yes.
you expressed, say we got a lot that's grandfathered in and this guy moves out and no longer is going to operate a lot. Can someone else come in and operate a lot there?
I believe, I'm going to look back to Rick. I asked Rick Robertson to be here tonight to speak to the zoning side of this. So I'm going to let Rick answer that question.
Good evening, everyone. To answer the question is, if the existing vehicle sales is in place and you as a property owner would discontinue or the applicant discontinue that use, you could reestablish that use within a 2-year time frame.
Under the current zoning.
Under the current zoning ordinance, that's correct.
I would like to see some kind of protection if this lot doesn't meet our new standards to create a hurdle here, because we've got so many of these goddamn little places all over the place. We got several of them. You're exactly right. You can't get off the road. I saw one down here 4 Mile Fork that they got the cars parked on the angle, and there's one little road in like this, and I don't know how they get cars in and out of it. Mm-hmm. And I know that's not going to meet the new standards we want to create here. And I would like to see if that guy closes down, that there should be some impact to the next guy that wants to operate a car lot there, especially since it doesn't meet the standards.
Thompson, I believe that's protected under state law. If I would have to defer to the county attorney's office on that, but that's state law that gives grandfathering. It's not just local ordinance.
Mr. Chairman.
Yes, sir. Yes, Mr. Burns.
Thank you.
Mr. Thompson is absolutely 100%, and it may be, but I think we have to, if we're going to get at this nut and try to crack it, I think the best way to do it is to find out, if somehow or another in the changes in the county ordinance that we can address that 2-year period.
Yes, sir.
And if we can't do it there, the board might want to, since the board's concerned with it too, they might want to put it on their legislative agenda list to somehow or another allow Spotsylvania County to have the authority, since the Dillon rule state anyway to be able to do it. But if we're going to get at it, that you're exactly right, Richard. I mean, let's get at it. And the way to get at it is though there are a grandfather, but if something shuts down, give us a smaller one at a time so that, you know, we can deal with this thing.
Less than the 2 years that I believe he said 2 years.
Yes, ma'am. But certainly, if I may, I've read this ordinance, and I don't want to interrupt Wanda's presentation too much, but this is certainly on the right track. So, but summarized, it is protected for a period of 2 years.
Right, so continuing on with the details of the proposed amendment, new definitions would be established. One would be vehicle sale, rental, and ancillary service establishment, and that's currently in our ordinance, but we'd add larger scale or smaller scale to identify which ones are allowed by right and which ones would require the special use. So the larger scale is, in this draft, defined as 2+ acres. So anything 2 acres or larger would be considered larger scale and be permitted. The smaller scale are less than 2 acres. And I've noted here that we did an analysis of the commercial 3, industrial 1, and industrial 2 parcels in the county, and there are 512 parcels that are 2 acres and greater of those zoning districts, and less than 2 acres, there are 1,198. So, you know, there is a vast majority of these parcels are smaller parcels. So as I said, the larger scale would be permitted and the smaller scale would then require that special use. Jacob was just talking about eliminating some provisions from this section 23-457 related to places of worship and wineries because they're special uses, and these are special provisions associated with special uses. And in this case, I'm actually proposing to add some, but mine that I'm proposing here are a little bit different character, whereas the ones that we're proposing to remove right now are conditions. They speak to the architecture of the building or whatever it might be that would be something that would typically be a condition of a special use. This establishes some additional application requirements for these special uses. The vehicle establishments do get licensed and inspected through the state, and they have some very simple requirements in terms of establishing a business. And one of those is that they need to have a minimum of 10 parking spaces for their vehicles on site. They need to have an office space. They need to have working internet and telephone. So they're very basic requirements. So what we're looking at here to get at these specific issues that we've identified is requiring that with the application, the applicant provide a vehicle delivery statement which details how stock vehicles will be delivered onto the site. So we're not dictating how they'll be delivered because I understand they're delivered by various means, some of which purely are driven on the site from other locations, and some of them are brought by truck. So this delivery statement then would give, if there was an issue in the future, give the zoning office some enforcement ability to go back and say, well, you're now operating under a different type of delivery than what you had detailed in your permit, and so you're out of compliance. We also are looking at a certified parking plan that shows all parking spaces, labels sizes, and designates which are for use by customers and employees in the vehicle stock. And again, keying in on that 10 paved vehicle spaces per dealership that is also meets with the state minimum. Indicate which driveways the vehicle delivery truck will use to access the lot and the loading space on site. And that if there are dealerships sharing one lot, the parking plan must demonstrate that the parking requirements are met for each individual dealership. We do have some locations where there are multiple dealers on one site, for example, the one that recently opened near 4 Mile Fork. So these are all additional application requirements so that we can better understand how the site will operate, but also these can then be conditioned, and zoning could go out and look at their parking plan and say, you're parking on grass, that is not appropriate, that you're parking outside of in drive aisles or different areas that were not designated as parking spaces.
So these are for smaller,
This is for the less than 2 acre sites.
less than 2 acres, and the definition of a dealership is one that is licensed by the state.
Yes, the dealer is, the independent dealers and the franchise dealers, they're all licensed by the state. Both types. So any dealer is licensed by the state.
Okay, so can someone, so someone in the Commonwealth of Virginia cannot sell a vehicle without a license? Not privately, but.
Right, if you're going to establish yourself as a dealer, as I understand it, even if you intend simply to sell vehicles over the internet, using the internet, you need to have a physical location. And so you need to have 10 spaces for vehicles at that site and meet some basic minimum requirements. And the state does require that the proposed dealer come to the county and get signed off in terms of meeting the zoning ordinance requirements, but oftentimes, like I'm pointing out with these non-conforming lots, it meets the requirements because of the zoning.
Okay. Yes, sir.
Wanda, does this include boats?
Or campers, or RVs, or anything with an engine?
The reason I'm asking is
Yeah,
because
it's a
on
great question.
Courthouse Road, there's one that's just recently opened up, and it looks like a used car lot, only it's boats, and they're parked on the side of the road in the grass everywhere.
I would, let me just pull up the
Great
ordinance
question.
very quickly. Sale, rental, and ancillary service of vehicles and operating conditions such as automobiles, motorcycles, ambulances, taxis, vans, recreational vehicles. Not include heavy equipment, specialized vehicle sale, rental, and service establishments. However, specialized vehicles such as a pickup truck may be sold and rented as an ancillary use. So recreational vehicles, Rick?
Specialized vehicle.
So
when it says specialized vehicle, that includes boats.
So yes, it would include boats. Yes, as it's written now, it would include boats. Yes, that's how zoning's been interpreting it, yes.
I don't actually know that off the top of my head. However, I would think that as an application runs through planning, it also runs through zoning, so that if the zoning department saw that there was an issue with a specialized vehicle that they considered a boat, they would flag that. Am I correct, Ms. Parrish?
That's correct. Mm-hmm.
Wanda, is there a definition section that's going to be included or that's already included in the code that defines specialized vehicles to include boats? Okay, that's what I was curious about.
And if not, the definition that's here that is proposed to be amended, we could enhance that to say to include boats. I mean, that would be a simple addition. So staff is seeking the Planning Commission's feedback, and I've got a couple of notes here already. Related to the draft ordinance, next step will be that we'll fine-tune the ordinance based on the comments made this evening and based on the legal review. And then this was requested by the Board of Supervisors, so we would then bring it to the Board of Supervisors, review it with them, and determine if they wish to move forward with public hearings.
Yes, Mike.
So one of the things that I've noticed in this, and I've been following this pretty intensely because I've noticed this myself, right? The parking on the grass and inability to get in and out of the parking or in and out of the establishment. Who enforces when individuals or establishments park outside of their parcel? Giving examples that one of the special use permits that we had for Tidewater and Shannon Park Drive right there, the applicant was up here and we asked the question, are you going to park on grass? And he said, no, we absolutely are not going to do that. And if you look at the landscaping there, you can see there's no way possible they could have without taking all that down. So of course they're going to say that. There's a sidewalk up front. However, they had 4 vehicles on the grass that almost looked like it was going down almost to the stormwater area or the stream or something along those lines. 4 or 5 parked there. Another gentleman who has a dealership that didn't come with a special use permit, it's been here for forever, at Harrison and Route 1, actually parked his vehicles on the mounds of dirt and rocks on the weekend that VDOT had piled to the side to put the turn lane and expand that whole intersection. Is there nothing that can address those situations now, or is that just typically what we're trying to enforce even more so? I don't want those to be grandfathered in, and I don't think that they are, but how do we enforce when stuff like that happens? How do we make sure that just doesn't happen? It doesn't look good.
Yeah, so zoning is the enforcer of the zoning ordinance as well as any conditions and proffers for special use and rezoning, so I'll defer to Rick to answer that one.
We are charged with the responsibility of enforcing the site plan, what the approved site plan is. I know currently the business that you're speaking about on Tidewater Trail, that all I can say about that one is that it's being addressed, it's being investigated right now, and we're supposed to draw that to a conclusion very soon. So this is what happened with the proposed change in the ordinance. Really gives us the teeth now, where it says in there where, for example, you have to, when they come in and apply for an application and they've got an approved site plan, exactly what we're dealing with right now, because that is a violation of that site plan, and that's how we would address that. And so with the teeth that they're giving to me now would certainly bring most of these concerns to heel, if you will.
Right. How is that enforced? Once you go down there and they're in violation, I mean, are they written a citation? Are they fined?
Yeah, what's happening? What'll happen is typically we complaint act response by complaints only for the most part. We do dispatch an officer down there. They do investigate it. They take their pictures. They gather their evidence or whatever it may be. And once it's determined that there is a violation, they are given a violation. And by law, at a very minimum, the state law says I have to give them 7 days to comply. Well, that automatically kicks in the appeal process too. So we found it beneficial to give a notice of violation consistent with, in some cases, consistent with 30 days. It goes along with the appeal process. So it goes hand in hand. Normally it takes them more than 30 days to create these problems, and usually it takes them 30 days to solve them, so especially with parking being at a premium. So I haven't met a car dealer yet that it's not enough parking with them. It's just simply, you can give them 100 and they'll need 150. You give them 150, they'll need 200. It's that simple. So that's the process for it.
Any other questions? Anything else, Wanda?
No, that was it on this item.
And you don't need any action tonight from the?
No action.
Okay. If there are no other items under the work session, under new business, we have public input portion of the comprehensive plan.
Yes, I've been tasked with going to the Board of Supervisors at their second meeting this month to talk with them about the idea of a strategic plan. A couple of times now, the board has brought up the idea of a strategic plan, but we don't know exactly what that means at this point. So the purpose of that work session is to talk about what is the vision that the board has for a strategic plan. But there have been some comments over the last year that lead us to believe that it might be something akin to the comprehensive plan. It may be related to transportation. It may be related to growth. And so the idea is that I'm going to go to them, review the comprehensive plan with them, and we do have an introduction and vision section where if the board desired to develop a more land-based strategic plan versus something that's more of an organization-based strategic plan, that would fit very well to have that in that introduction and vision section of the comprehensive plan update. So as part of that, wanted to talk with them about how they wanted to approach that if they do want to go down that road, and what public involvement would be involved in that process, because we're also going to begin the comprehensive plan update. It's coming up on our 5-year update time. So I just wanted to get a feel from the Planning Commission if you've given any thought to what type of public involvement process you'd like to see as we move through this update. I outlined in an email 3 different basic ways. One of them is more of kind of a top-down version where the Planning Commission and Board take the lead. They develop a draft and then go out to the community and get feedback. Sort of a middle ground is what occurred at the last update, where the Planning Commission appointed specific people to serve on committees. And in that case, the committees looked at chapters of the comprehensive plan. They each focused on a chapter and then brought back feedback. And then there were larger community meetings resulting in community input in general before it was finalized and brought to public hearing. And then another version would be that there be no specific committees that work on the comprehensive plan besides the Planning Commission itself, and that you get public input up front, and that can be done in a number of ways. It could be that there are 7 community meetings, 1 for each voting district that focus in on that voting district. It could be that there be multiple community meetings based on a theme. There be transportation be one of the themes for one of the meetings, and they be general and open to the public to receive input that then is used to develop the comprehensive plan update. So I wanted to, because when I meet with the board, because it's likely that the conversation will head in that direction, what is the board's vision in terms of how to move forward, I wanted to also get feedback from the Planning Commission so that I could let them know what you're thinking at this point in terms of the comprehensive plan update.
Any comments? Richard?
I have one. I think the way we did it last time was a long, drawn-out affair that was confusing, and I'd rather soon not go through that process again. Now, whether we want to do all this and then present it to the people to look at and make comments, or whether you guys want to work with it, how would you do that? We would work with you?
Yes.
We would do that here.
Right. We would work through the sections.
I like that idea. I like to have a hands-on input with you guys and make changes or leave things alone however we see it. That's the way I like to do it.
Okay. So the question then would be, would we receive input from the community before that happens or after that happens?
I think you would announce it and let people have something to say it, and then we consider it. I think it's less confusing. Because otherwise, the people that would be interested in it at that point would make comments. I think you can confuse and create a lot of extra work doing it any other way.
Spotsylvania government channel?
Yes, it certainly could. Well, all of our Planning Commission meetings are televised.
I know, but
so,
I mean, this is separate, this is what the planning commission is considering? Blah, 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 blah. I mean, it should be continued there. Because
Right.
there's just an overrun, over and over of different things. And when something special like this comes up, I think that it should be addressed.
Right, yes. We would certainly have a public outreach effort, Facebook, on the channel, newspaper advertisements, whatever it was to get the word out that we're working on the comprehensive plan update and that we are seeking comments.
Yeah, and then you would bring them to us during this process, and we consider it and go from there. Thank you.
Mr. Chairman, I'm not a fan of committees, so especially on strategic planning, I think there's responsibility to board supervisors and planning commission to some degree to get at least something generated so that you can get some comment, because the problem is, you know, a point in every direction, same thing as no point at all. A lot of times when you get out, you get all these different things. Having said that, though, there might be some advantage to having at least district meetings, in other words, for each district, like Berkeley, Livingston, Chancellor, and so forth, because the districts or battlefields a whole lot different than Berkeley, you know, to some degree. So the needs there might be a little bit different. So I think as far as getting all the things you're talking about, getting the word out, we have a work session here and put it on, you know, information out in media is great, but I think as in terms of meetings, you know, having it by a district would probably be, I think, the most, at least to get some input. I don't know how much participation you would get, but at least you'd have that opportunity so that people district-wise. For example, people in Berkeley would like to go somewhere close in Berkeley to go, and Livingston, they're not going to drive a long ways off to attend something. So if you have it convenient, that could be a possibility. At least that's my thoughts on it.
I would agree. I think we're spot on. I like to control the process, but get the community involved as early as we can, but control the process and keep the ball moving ahead. And you know, wonder how we do that. I guess we'll take your recommendation, but and I do like reaching out to the various districts because exactly that, there are specific needs in each district. So, do you have enough to go on right now for the board? Okay.
Yeah, I think so.
All right. Is there anything else under that we need to discuss on this item?
No, nothing under that item. And the only other item is that at the Planning Commission's pleasure, we'll cancel the next meeting since there's no business.
I don't think we need a motion for that, so we'll go ahead and do that. Yes, sir.
Not to extend this, but I had a question, a legal question that came out of our first case tonight. The Dollar General, or the attorney representing Dollar General, mentioned, I don't think he cited the section, but maybe he did cite the section, that stated I believe stated that you could not decline based on, you know, financial impact, not financial impact, but he was stating something where you couldn't deny it based on the fact that it may shut down a small business. And I wanted to see, one, if that was true. It may not be tonight. You may need to research that, whether that's true, and then whether the opinion that staff is giving us violates that in some way, shape, or form, if that is a reason for denial that's been given by staff.
I can actually tell you that what he cited was a Virginia Supreme Court case, and I actually know from speaking with Ms. Pomato that he sent her the case, so I will get a copy of that. There was nothing I heard from staff's report, which of course ended up recommending that Dollar General be put in this spot. There was nothing I heard there. What I believe happened is, and I talked to them afterwards but not beforehand, I believe that counsel for Dollar General heard the concerns of the public on the other side of the aisle in opposition and was moving to address or cut off at the pass anybody from the Planning Commission commenting on that by giving you a full frontal acknowledgement that the Virginia Supreme Court has said that you may not consider the impact on other businesses when considering a commercial entity in a specific location.
And so that was my concern. As I'm going back, and I believe that was one of the negatives that was stated in the proposal or in the staff finding. And if that's the case, should that ever be there? I'm just curious. I'm okay with it.
And
but
I could turn to the page, or I could ask Ms. Pomato to address it, but I believe what she said was allowing this rezoning to commercial is going to change the harmony or the nature of the area as it is now, because it's rather rural. But I will let Ms. Pomato speak to that. It's in the report.
Right. It was with respect to changing the rural character of the area.
Okay, thank you.
May I?
Yes, ma'am.
We need a legal opinion, which some of us think it is, know it is, and some don't. If a client comes in on commercial, and we want to meet with the client and suggest some issues that we would like to see addressed, we can do that. Am I correct? Without being, without that new proffer guideline of whatever's there.
The way that, and I would be happy to speak with you, I would either be happy to render a legal opinion for you to review, or I would be happy to speak with you at some point with regard to this. But the way that you, I believe, always want to express yourself is that you want to express the concerns that you have, as you did tonight about traffic. But what you want to say is that you don't believe the proffers mitigate your concerns, particularly with residential.
I know residential.
Yes,
I know
ma'am,
that, but I'm out at commercial now.
Right, but I would like to caution that, and remind you, not caution, I would like to remind you that all proffers are voluntary, such that conditioning a proffer approval on requiring an applicant to do something would be inappropriate and would put the county in an awkward position legally, and therefore that was why I made the comments that I made this evening.
All right, if I was to say, okay, if I was to meet with the client and it was a rezoning from residential to commercial, and I met with them on site, okay? I could say to them, it would be nice if we had a turning lane here. And then, and this is commercial. It would be nice if we had a turning lane here.
Ms. Carter, I would always like to caution you to be careful in your wording of things, that what you can say is, I have an issue. You did a very nice job this evening. I have an issue that there are traffic concerns here, and I do not believe your plan as it stands mitigates my traffic concerns, because making a right turn from a drive lane at 55 is really, I believe, going to be a problem. What you've done is address your concerns and say that what has been proffered does not mitigate the concerns that you have. But again, I would caution against, and the reason is it's very strict with residential, but I would just recommend that you get in the practice of expressing your concerns without making a request, suggestion, or anything like that to the applicant. They certainly picked up on it this evening.
I hope so. Well, let me say this. I would like for you to give each of the commission members an opinion and give us what you just stated to me and how you stated it, and I'll try to abide by it and not mine.
Yeah, thank you. And you know, we've expressed our concern, and what's difficult about this law is just that, is addressing our concerns. And, you know, we don't have a good platform to do that, you know, under this new law. That kind of restricts how we can do that, so. Anything else? Any other comment from the public? Very well, we'll take a motion to adjourn.
So move.
Second. Call the vote, please. Thank you very much.
Be safe, honey.
I'm going to do the best I can with what I got.
I'll pray for you in the morning.
Thank you.